Mr. Murali.
Mr. Deputy Speaker, sir, I declare my interest as a lawyer practicing insolvency law from time to time. Sir, I fully support the aims of the bill. It finally introduces the omnibus legislation covering personal and corporate insolvency laws, widely awaited by practitioners in the insolvency sphere. As the learned Senior Minister of State mentioned, it follows two reports, the 2013 report of the Insolvency Law Review Committee, as well as the 2016 report issued by the Committee to Strengthen Singapore as an International Centre for Debt Restructuring, co-headed by the learned Minister Ms. Indrani Raja and the Honourable Justice Kannan Ramesh. There was also an earlier report, the 2002 report by the Company Legislation and Regulatory Framework Committee, which made a clarion call at the outset for introduction of a consolidated new Insolvency Act. I applaud the Ministry for Law for leading the consultative process over such a long period of time, getting feedback from the players in this industry and implementing the recommendations that have been made. It's a long process, but it's worth the wait because we can see the complexities involved. 70 amendments through various statutes and about 150 recommendations have been provided to the Ministry for consideration. I would, however, make a point that in providing for these provisions to basically enhance Singapore's status as a premier debt restructuring centre, we must also need to balance against the creditor interests. Tilting against the creditors, especially banks, would result in higher business costs, and it may be more difficult for the banks to basically conduct its business, particularly given the regulatory requirements that it has under Basel III to ensure a better ability on their part to liquidate collateral in a timely manner. This may in turn impact Singapore's attractiveness as a financial centre, or if the cost of lending goes up, then the cost would be passed on to the businesses. As we all appreciate, the vast majority of companies in Singapore are solvent, so we must ensure that we cannot have a situation of the tail wagging the dog. We note that the 2017 laws have already, or rather, that in 2017, a number of legislation have been passed, making inroads into the rights of creditors. For example, the more extensive moratoriums, the possibility of rescue financing with the consequent super priority afforded to the rescuers, and also in relation to judicial management, it is now easier to get judicial management orders, and the rights of the secured creditors have been watered down consequently. It's in this context I wish to seek an explanation from the learned Senior Minister of State. How do we strike the balance between the need to maintain our reputation as a financial centre and our intent to build Singapore as an international centre for debt restructuring? And it's in that context that I wish to seek a fuller explanation on the proposed Section 440 of the bill. My parliamentary colleague, Mr. Christopher D'Souza, spoke eloquently about it just a few minutes ago. From my sensing, there is some level of nervousness on the impact of this provision. Take, for example, a bank or securities company that provides margin financing to a company trading in listed securities. The bank itself is exposed to the stock exchange or the clearinghouse when putting through the trade transactions of a company that's distressed. The securities company has to itself place margins with the clearinghouse or stock exchange. If it cannot enforce through the exercise of ipso facto clause to terminate these facilities, then there is a potential exposure to them. This may affect the bank's practice, which may become more conservative in providing margin facilities. And this may in turn have some far-reaching or unintended consequences. In an economic situation where providing liquidity becomes important to keep companies afloat, this becomes even a greater issue. There are carve-outs in other jurisdictions. For example, in the EU, there's a financial collateral directives. The Honourable Senior Minister of State mentioned that there could be carve-outs in relation to eligible financial contracts. I seek clarification as to what are the exceptions that may apply in relation to Section 440. In that regard, I note that Section 440, subsection 5, contemplates a carve-out for eligible financial contracts. I also would like to ask whether the industry has been consulted on this provision, and in particular because both in the 2013 and 2016 reports that I referred to earlier, this provision was not specifically recommended. Another potential effect would be in relation to the private wealth management business. Would private banks rather use offshore SPVs rather than, as opposed to Singapore SPVs, because of the potential for Singapore insolvency laws applying to these offshore SPVs? Or alternatively, minimize the transactions such that there would not be a substantial Singapore connection between the foreign SPVs and Singapore. And this substantial connection test is the basis upon which the Singapore courts can exercise jurisdiction over a foreign SPV. Notwithstanding what I've said, I support the bill.